Deputy Michael McNamara.
Thank you very much, Las Corla. I intend to be brief. There are a lot of speakers who wish to speak on this important issue. We've heard a lot in recent days about conscience, and in particular tonight about conscience and the importance of voting with your conscience. And I salute each and every member of this House tonight who will vote with their conscience on this important issue. But I think it needs to be said that people on both sides of this House will vote with their conscience. And people will vote with their conscience when they go through both of the lobbies tonight. Because there's something hanging in the air that somehow only those who oppose either Section 9 of this bill or the bill in its entirety are voting with their conscience, and the rest are voting somehow in political expedience. Nothing could be further from the truth. Was it conscience that led this legislature for the 9 years from 1983 to 1992 to legislate for when a pregnancy could be terminated in order to save the life of a pregnant woman? And I accept that that legislation at that time would not have included suicide as a ground. Was it conscience that led this legislature to ignore this issue? Or was it political expedience? Was it fear of powerful political forces in the land? Was it conscience after 1992 when the Supreme Court clarified exactly what the meaning of 40.3.3 was, and the Chief Justice stated, "I therefore conclude that the proper test to be applied is that if it is established as a matter of probability that there is a real and substantial risk to the life, as distinct from the health of the mother, that can only be avoided by the termination of her pregnancy, such termination is permissible having regard to the true interpretation of Article 40.3.3 of the Constitution." And of course we heard tonight that the Supreme Court can't order this legislature to legislate for something. And that is indeed correct. But it's important to also bear in mind that it is for the Supreme Court to determine what the Constitution means. The Constitution as chosen by the people, not by this legislature. Was it conscience that forced those politicians to ignore that judgment for 10 years? Or sorry, was it conscience that led, after there was a referendum in 1992 to remove suicide as a ground, that referendum having been rejected? Was it conscience for 10 years that led the legislature to do nothing? And then in 2002, there was another bill put to the people to remove suicide as a ground. And it was again rejected by the people. Well, was it conscience that led the House to again ignore the people and their Constitution? I say it wasn't. I say it was political expedience. And I think that needs to be recognised. Was it conscience that led some people to somehow suggest that the X case was invalid, that it was all some kind of an obiter dictum? And of course it wasn't. Yes, the circumstances of Ms. X changed after the judgment. But an obiter dictum is defined in Murdoch's Dictionary of Irish Law as an observation by a judge in a case on a legal question based on facts which were not present or not material. But all of the facts were present in the X case that the Supreme Court decided upon. They were all present, they were all relevant. They may have changed later, but that doesn't in any way render this judgment obiter. It was and remains a valid judgment. And I don't... Also, the issue of Cosma was somehow cited. Cosma was a conflict involving a woman who threatened to commit suicide because she was being deported. Whereas the X case involved a very real dilemma and a conflict between vindicating the life of a girl and the right to life of the unborn, whose life was dependent upon that girl's life. That's an entirely different scenario from Cosma. In the X case, McCarthy noted that the right to life of the girl here is a right to a life in being. The right of the unborn is to a life contingent on survival in the womb until successful delivery. If there was any fault with the X case judgment, or indeed the X case, it was that it was conceded that there was indeed a threat to the life of the mother through suicide. But of course that will not be the case in real issues that will come before a panel of doctors who have to adjudicate in accordance with Section 9. Because under Section 9, it shall be lawful to carry out a medical procedure in respect of a woman in accordance with this section, in the course of which, or as a result of which, an unborn life is ended, where 3 medical practitioners, having examined the pregnant woman, have jointly certified in good faith that there is a real and substantial risk of loss of the woman's life by way of suicide, and in their reasonable opinion, being an opinion formed in good faith, which has regard to the need to preserve unborn human life as far as practicable, that risk can only be averted by carrying out the medical procedure. Well, we see that the real and substantial risk term is exactly that used in the Supreme Court. And of course, it won't be conceded. It is for 3 suitably qualified medical practitioners to determine whether or not there is a risk of suicide, a risk to the life of the woman posed by suicide. It's not a matter of a legal concession or something as trivial as that. It is for 3 medical doctors to determine. And yes, it is a matter of life and death. That is why there are 3 suitably qualified medical doctors who will determine that issue. Thank you. I commend this bill and indeed Section 9.